Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk today a little bit more about this post-Bruen enlightenment, where we're going back and we're doing some serious soul searching about some of the old laws that we've had on the books in some instances for decades now, and asking ourselves, hey, were these things even constitutional to begin with? And today, what we're going to be talking about is the National Firearms Act, and in particular, suppressors. Texas, as you may know, passed a law about 3 years ago that basically said, hey, if you make and manufacture a suppressor here in the state of Texas and you leave it here in the state of Texas, well, then the NFA doesn't apply to that. Of course, that got the federal government's shorts all in a knot. They got really, really pissy about it, sent a nasty little letter to the state of Texas, and away we go. We have ourselves a lawsuit. But I got to be honest with you, had an opportunity to read the state of Texas brief. They make some pretty darn good arguments, and I think this is really just the tip of the iceberg of a very large litigation movement that we're going to see nationwide over the next few years. So today, let's spend a few minutes and let's talk about the beginning of the end for the National Firearms Act. Okay, so what we're talking about today are suppressors of the National Firearms Act and the state of Texas. In particular, we're talking about the case of Paxton v. Dettlebach. It is a case that is now on appeal to the Fifth Circuit after the trial court dismissed the lawsuit, basically granted the United States government's motion to dismiss the suit, saying that none of the named plaintiffs, and the named plaintiffs here are 3 individuals, plus the state of Texas. And he basically said that none of the 4 plaintiffs in this case could show any injury of fact and dismissed the case, which essentially it got dismissed on standing. And for those of you, of course, who geek out on this channel all the time, you know that standing is the great argument that the government always makes when they actually don't want to get into the merits of the argument itself. Okay, so like I said, the law in question here was actually passed all the way back in 2021 in the state of Texas. It's Texas Gov't Code 2.052A, and it read as follows. A firearm suppressor that is manufactured in this state and remains in this state is not subject to federal law or federal regulation, including registration. Now, to give you an idea more specifically exactly how this law worked, the Attorney General for the state of Texas points out, the individual appellants reside in the state of Texas and are citizens of Texas. They intend to make a firearm suppressor for their own non-commercial personal use. The firearm suppressor will be made in their homes from basic materials without the inclusion of any part imported from another state other than a generic or insignificant part, such as a spring, screw, nut, or pin. They intend to own the firearm suppressor in perpetuity, to never transport it outside the boundaries of the state of Texas, and to never transfer it to another person. They intend to use the firearm suppressor with a personal firearm exclusively for the purpose of self-defense. And I think that is important. All of those little limitations there, that they reside in Texas, they're going to keep it in Texas, it's going to be manufactured in Texas, all major components will come from the state of Texas, the suppressor will remain in the state of Texas and will never be transferred to another person. That is a bunch of limitations on the factual scenario here that actually makes this argument far more plausible. Now, despite the fact that the state of Texas exercises its own sovereignty, its state legislature passed this law, well, the ATF got really, really pissy about it and actually, back on July 28th of 2021, sent them a nasty little open letter, as the Attorney General for Texas pointed out. On July 28, 2021, ATF issued an open letter stating that because Chapter 2 of the Texas Gov't Code directly conflicts with federal firearms laws and regulations, federal law supersedes. In summary, all provisions of the Gun Control Act and the National Firearms Act, including their corresponding regulations, continue to apply to FFLs and other persons in Texas. And away we go with a lawsuit at that point. Now, I should actually point out, if you look at the legislation, the Attorney General of Texas is not doing this to try to score some kind of political points. He's not out there like we've seen some other prosecuting attorneys trying to make a name for themselves. No, actually, Ken Paxton, the Attorney General for the state of Texas, was directed actually directed by the Texas state legislature to challenge and to find a way to uphold this law. So he was tasked with actually suing the federal government over this. The crux of the argument, as you would expect it to be, really is again based in the Bruen analysis. As the plaintiffs point out, the National Firearms Act of 1934 was amended in 1968 to regulate for the first time the making of firearm suppressors for non-commercial personal use in Texas. But defendants cannot demonstrate any historical tradition that can be analogized to any feature of NFA's regulatory regime that applies to the making of firearm suppressors for non-commercial personal use in Texas. Therefore, the statute establishing that regulatory regime and defendants' rules and practices implementing and enforcing that regulatory regime are unconstitutional. As a result, 18 U.S.C. Section 922 G8 falls outside the class of firearm regulations countenanced by the Second Amendment. Now, one of the other reasons why I think this lawsuit really can gain some traction is that there has been a massive shift in public perception about what the use of suppressors really are. I get that back in the 1930s, they were the predominant use and tool of those engaged in organized crime. But that is no longer the case now. And with the advancement in short barrel rifles and firearms with attached stabilizing braces, the use of suppressors have become far, far more commonplace. As the plaintiffs point out here, in the past several years, opinions about silencers have changed across the United States. Their use to reduce noise at shooting ranges and application within the sporting and hunting industry are now well recognized. At present, 42 states generally allow silencers to be used for sporting purposes. And if we have a tradition of regulating items which are dangerous and unusual, what do we do with an item such as a suppressor, which actually makes firearms less dangerous in the sense that it is less likely to cause damage to our hearing? As a matter of fact, the Center for Disease Control, take it for what it's worth, they're on board with this premise. Recently, they were quoted as saying, "The only potential effective noise control method to reduce noise exposure from gunfire is through the use of noise suppressors that can be attached to the end of the gun barrel." Currently, there's approximately 2.6 million registered suppressors in the United States, and 500,000 of those, they reside inside the state of Texas. So when we take a look at all of this data, when we take a look at all the utilities of a suppressor, and I use the term suppressor, not silencer, because if you're familiar with it, you notice that they will not silence anything. Will they significantly reduce the noise? Absolutely. To call them a silencer is a misnomer. But when we circle back again to all of the data, how commonly it is used, how frequently it is used, how frequently it is used for lawful purposes, the plaintiffs correctly point out, in short, firearm suppressors are in common use today and are neither dangerous nor unusual. Now, as I had mentioned, the trial court had originally thrown this lawsuit out because the three individual plaintiffs said, well, we want to get a suppressor, but we haven't been able to do so because of this law. And the court found that that was no injury in fact. As a matter of fact, they basically said, well, you really need to go out and violate the law, and risk yourself with going to prison and things like that. And then, of course, we can take up the constitutionality of it. They also found that the state of Texas itself had no injury in fact either, and therefore they were dismissed from the suit as well as lacking standing. Now, obviously, the state of Texas is appealing that, and they're doing so as follows. The individual appellants have injury in fact because they wish to make a firearm suppressor for non-commercial personal use in Texas without complying with the NFA's unconstitutional application, tax, serial number, and registration provisions, but face a credible threat of prosecution if they do. For pre-enforcement review of criminal prohibitions, it is not necessary that the plaintiff first expose himself to actual arrest or prosecution to be entitled to challenge the statute that he claims deters the exercise of his constitutional right. Okay, so that covers the injury in fact for the three individual named plaintiffs, but what about the state of Texas? Well, they respond as follows. The unconstitutional regulation of firearm suppressors adversely affects Texas's health and well-being by delaying by 60 or 55 days when the application is approved, or prohibiting when the application is not approved, Texans' ability to use firearm suppressors for the purpose of home defense as demonstrated by the affidavits of the individual plaintiffs. Therefore, Texas has standing to vindicate its quasi-sovereign interest in its citizens' health and well-being. And that is what really makes this issue so fascinating, is that those that are challenging the law, that is, want to make sure that suppressors can be more easily obtained, are actually arguing on the side of health, because that is the most effective way to protect your hearing for those that are engaged in the act of shooting. But more importantly, I believe that this is just the very tip of a very large iceberg of litigation that we are going to see. We are going to have this awakening moment. We're going to start taking a look at the National Firearms Act, which was not passed until 1934, well after any of the historical time periods for which courts have instructed the government to look for support in those laws. We are going to see this push again and again on suppressors, and ultimately it's going to lead to the erosion and potentially the ultimate destruction of the National Firearms Act. The case, once again, is Paxton v. Dettlebach. We'll link it up down below so that you can geek out on it for yourself. If you guys got any ideas for videos that we should be doing here at Washington Gun Law, go ahead and click on that link right there. Some of the best ideas we ever had weren't really our ideas. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is down there in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.